Is it a crime if the government is doing it too? In Camp John Hay, the government accused a developer of running an illegal investment scheme. But what if I tell you that the government was actually an investor in that same scheme? Let's talk about how the state profited from the very deal they declared a crime. To understand why the developer, CJHDevCo, was the victim in this regulatory war, you have to look at what happened before the courts got involved. The government accused the developer's Leaseback program of being an illegal, unregistered security. But here is the bitter irony. The government knew about this program. In fact, they participated in it. In 2010, the BCDA accepted 26 Condotel units from the developer as payment for debts. These units are in the same leaseback program. They collected the same rental revenue. When the government was making money from it, the program was fine. But when they wanted to pressure the developer, suddenly that same program was labeled illegal. CJHDevCo wasn't a criminal enterprise. It was a partner trapped in a double standard. Despite these conflicting signals, the legal process moved forward. The SEC petitioned the Supreme Court to reinstate the original cease and desist order. When the High Court ultimately ruled to restore the ban, CJHDevCo complied and immediately stopped all unit sales. But if you read the fine print, the developer wasn't proven guilty. The Supreme Court ruled on procedural grounds. They stated that the developer failed to exhaust administrative remedies, meaning they should have finished the arguments at the SEC office before running to the courts. Crucially, the Supreme Court did not rule on the merits. They did not declare that the leaseback deals were definitely securities. They left that question open. Yet, the punishment was real. The sales stopped. The developer suffered. For years, the developer argued that they were operating in a gray area because there was no specific law for Condotel leasebacks. They were punished for breaking a rule that didn't exist. On July 16, 2024, the SEC issued Memorandum Circular No. 12. For the first time in history, this document formally defined offers to sell Condotel units with rental pool agreements as securities subject to regulation. This was the first legal framework specifically addressing these transactions. Think about what that means. If the SEC only created the specific rules and definitions in 2024, how could the developer have knowingly violated a clear standard in 2012? The timeline tells a tragic story of business regulation. CJHDevCo was penalized, shut down, and dragged through court for years. And only in 2024, long after the damage was done, did the government finally write the clear rulebook for the game.